This is Law Journal.
Well, it may not show up on a CAT scan or an MRI or on an X-ray, but it could be one of the more insidious injuries that you could ever experience. And that's when you have a head or a brain injury. You might end up with psychological damage, neurological damage, mental problems down the line. They could affect you for the rest of your life. So how does an attorney handle that case? Is it an easy case to handle for a plaintiff's attorney? And if you're representing an insurance company or a doctor or hospital, is it difficult to defend? Good evening, I'm Attorney Christopher Naughton, and this week on Law Journal we delve into the area of personal injury, specifically brain injuries, head injuries, neurological and psychological damage. How do you handle those kind of cases? Let's ask the quote-unquote experts. Three people join me here tonight on the set. Stephen Scheller to my immediate left with Scheller, Ludwig, and Beatty, hailing from downtown Philadelphia. And Marlton, New Jersey. Steve is well known nationally for his product liability and medical malpractice work. The firm handles just about every range, if you will, of personal injury matters. Seated next to him is Pat Iyer, and it's been a little while since we've seen Pat, a good year ago. Pat is not only a registered nurse and an author, but heads up her own company. She's president of MedLeague Support Services, and in a word, in a nutshell, they do quite a bit. They represent, or they actually help plaintiff and defense attorneys in personal injury cases, and maybe even more specifically medical malpractice, but the entire range of personal injury. It's always great to have Pat on the show. We can get her here about once a year. And Frank Allen joins us tonight from Archer and Greiner, one of New Jersey's prominent law firms, especially in the western sector of the state. They also have a presence in Pennsylvania. Frank has joined us before. Very colorful, very insightful, always has a couple of good things to say on the show. And he represents both plaintiffs in personal injury matters, and has also, he and his firm have represented doctors and hospitals in the same types of cases, medical malpractice and the like. You know how I like to start the show? Let's rip it on down the line, more or less, 10 to 25 word answers. Are these cases, neurological and psychologically related cases, more difficult to prove than something more overt, let's say a broken limb? What do you think?
I think the answer in part is in the medical records and looking at what the person was like before the head injury and what they were like after, and being able to look at other stresses or problems in their lives and separate out what are the effects of the injury versus what are other life forces going on.
Both Pat and Frank, you probably come a little bit more closely to representing defense interests in these kinds of cases. Do you think that these are also difficult cases to defend?
They can be if the injuries are clear-cut, if there's evidence on the diagnostic testing, if you have a perfectly healthy person before the accident and then you have devastating injuries after. Those are the difficult cases to defend.
It's interesting, Pat, because again, I know the kind of work you do is you're accumulating data and you're accumulating evidence, again, whether it's for plaintiff's attorneys or defense attorneys, often in medical malpractice cases. And now you're dealing with a phantom pain, or you're dealing with a neurological injury that may, again, a person just can't remember as well, can't read as quickly. From your standpoint, what are you grasping at?
Well, we're looking for patterns of behavior. We're looking at what the neurological testing shows. We're looking at whether or not there was testing for malingering, whether there are certain test results that show up that show that the person is exaggerating their symptoms, overreacting, behaving in testing situations worse than a head-injured person because they think that that's the type of test result that is expected. And
in other words, they actually may try to jury rig this test, if you will?
They may try to. It's not common, but there are some people out there who attempt that, and it causes some widespread cynicism among the healthcare professionals.
Do you think part of it might be that they feel like they're not going to be believed by a jury or by a judge or by a defense attorney, so they almost have to play it up a little bit that, you know, I can't remember my wife's name or what have you, or my middle name. Obviously, that's a little extreme, but although I've heard of stories. But anyway, we won't go down that path. But I mean, is that the kind of thing where maybe they're overplaying it because of the skepticism on the other side?
I think it influences some people. Again, not the majority of people, but there are some people on the outlying areas in terms of deficits that will exaggerate.
If you're claiming psychological injuries, again, neurological, psychological injuries, don't you open up your past, your entire therapeutic, mental, psychological past? Doesn't that become an open book? And is that fair? Pat Iyer.
Well, it's not only your past, but it's also your present, because sometimes patients will be sent to counselors for dealing with the stress associated with their head injury, and the medical records will contain documentation of all kinds of things from their childhood, from their current marriage, from things that get into the medical records that are the most intensely personal information that could be put in written form, and it becomes the knowledge of everybody involved in the suit.
Obviously, if you've got someone, again, who's claiming to suffer from psychological or neurological damage or problems, you have to know their background too. You have to get into all the grimy details from the past. That's going to affect whether you're going to be bold enough to challenge, often defense counsel, in this kind of matter, and willing to march in front of a jury.
I was an expert witness on a case of a patient who was struck in the face by a nurse who was about ready to faint. And I took the position that that was abuse, that the nurse should not have slapped her in the face. And this woman claimed post-traumatic stress disorder and went to a psychologist. And the records were replete with all of her family trouble. The case was settled for a low amount. And all this woman's dirty laundry was part of the lawsuit to try to refute the damages that she claimed as a result of being struck by the nurse. Now, I know the nurse shouldn't have struck the patient, but as a nurse, I can't say that all of these other things were related. That's not my role. That really was the psychologist. I said it was a part,
have you
but
seen
not all
defense,
of it.
again, Pat, since you represent both plaintiffs and defendants in these kind of matters, have you seen instances where defense has played dirty with psychological information?
I think the temptation is there. I think I've seen it in a few cases. I think it probably goes on behind the scenes more than I'm aware of as an expert witness on a particular case. But if I'm a consultant, I always bring it to the attorney's attention and let them decide how they're going to handle that. If that's a plaintiff case, whether they want to continue to represent them. If it's a defense case, how they're going to use that for their advantage.
Pat Iyer joining us tonight from MedLeague Support Services in Flemington, New Jersey, serving the legal community primarily in matters normally dealing with medical malpractice and personal injury, both plaintiffs and defense counsel. Gathering information, gathering evidence, expert witnesses, and the like for matters that are ready to go to trial and often do go to trial. Pat's also been very much involved in elder law litigation as well, especially in the last year. We're going to get to that in one of these programs, I promise you, Pat. Visit them at medleague.com or call them at area code 908-788-8227.